Ready? Exercise number 23, legal matter. Very important matter. Start. In view of the authoritative pronouncement of the Supreme Court in case of Commissioner of Customs and Central Excise versus Mrs. Hongo India Private Limited and another under bracket 2009 5 SCC 791. This question does not need further elaboration. Paragraph 20 of the judgment, which is relevant in this regard, reads as follows. Quote, next para. Though an argument was raised based on Section 29 of the Limitation Act, even assuming that Section 29 subsection 2 would be attracted, what we have to determine is whether the provisions of this section are expressly concluded in the case of reference to High Court. It was contended before us that the words expressly excluded would mean that there must be an express reference made in the special or local law to the specific provisions of the Limitation Act of which the operation is to be excluded. In this regard, we have to see the scheme of the special law here, in this case, is Central Excise Act. The nature of the remedy provided therein are such that the legislature intended it to be a complete code by itself, which alone should govern the several matters provided by it. If on an examination of the relevant provisions it is clear that the provisions of the Limitation Act are necessarily excluded, then the benefits conferred therein cannot be called in aid to supplement the provisions of the Act. In our considered view, that even in a case where the special law does not exclude the provisions of sections 4 to 24 of the Limitation Act by an express reference, it would nonetheless be open to the court to examine whether and to what extent the nature of those provisions or the nature of the subject matter and scheme of the special law exclude their operation. In other words, the applicability of the provisions of the Limitation Act, therefore, to be judged not from the terms of the Limitation Act but by the provisions of the Central Excise Act relating to filing of reference application to the High Court. The scheme of the Central Excise Act 1944 support the conclusion that the time limit prescribed under section 35H under bracket 1 to make a reference to High Court is absolute and unextendable by court under section 5 of the Limitation Act. It is well settled law that it is the duty of the court to respect the legislative intent, and by giving liberal interpretation, limitation cannot be extended by invoking the provisions of section 5 of the Act. Bearing in mind the principle aforesaid, we proceed to consider the scheme of the Act. It hardly needs any discussion to hold that the Act 1961 is a complete code in itself. Chapter 20 of the Act 1961 deals with appeals and revision. Section 249 of the Act 1961 provides for appeal to the Commissioner and the limitation thereto, and subsection 3 thereof specifically provides that the Commissioner under bracket appeals bracket out may admit an appeal after the expiration of the period of limitation if he is satisfied that the appellant had sufficient cause for not presenting the appeal within time. Section 253 of the Act 1961 provides for appeal to the appellate tribunal and the limitation for filing the appeal. But again, subsection 5 thereof confers power on the appellate tribunal to admit an appeal after expiry of the period of limitation. The power of the commissioner under bracket appeals bracket out and the appellate tribunal to condone the delay is not hedged, and they can condone the delay of any period. However, Section 256 of the Act 1961, before its omission by the National Tax Tribunal Act 2005, though provided for the appellate tribunal to make reference to the High Court, and the limitation for filing such an application for reference was 120 days. But the proviso thereof had given power to entertain an application within a further period not exceeding 30 days. The proviso to subsection 3 of section 264 of the Act 1961 providing for filing revision also contemplates admission of an application beyond the period of limitation on showing sufficient cause. It is relevant here to state that proviso to subsection 1 of section 269G of the Act 1961 provides for extension of period of limitation for filing an appeal before the appellate tribunal against an order of the competent authority under section 269F of the Act 1961. Not only this, in relation to an appeal to the High Court against the order of the appellate tribunal under section 269G of the Act 1961, jurisdiction has been conferred to the High Court to admit the appeal after the expiry of the period of limitation on an application made before the expiry of the period. In the background aforesaid, when one considers the provision of section 260A of the Act 1961 providing for appeal to the High Court, it is evident that no such power has been given to the court. Absence of any provision in section 260A of the Act 1961 conferring jurisdiction to condone the delay in filing the appeal, and in view of the scheme of the Act referred to above, in our opinion, provisions of sections 4 to 24 of the Act 1963 would not be applicable in the case of an appeal preferred under section 260A of the Act 1961. Now, referring to the decision of this court in the case of Harbir Singh under bracket supra bracket out, same in no way supports the plea of the appellants. Various provisions of the Act 1961 which we have referred to above signify exclusion of the Act 1963. Full stop. Thank you very much. Guys, again I am requesting, please always try to repeat the matter, then only your accuracy and fluency will improve, because accuracy and fluency is very important part of stenography. And there is one more request, if you found the matter is excellent, you can give your valuable comment on my YouTube channel. And also I am requesting, please subscribe my channel so that you can get the next notification on legal matter. Thank you very much guys.